We shall begin shortly. Well, welcome everyone. My name is Chris Cleary with the law offices of David Carrier. And today we will be doing our educational series on the 4 burdens of probate and how to avoid them. With us today, we have our probate attorney Terri Macklin, who also does litigation and has helped us in many other areas serving our families. I'd like to start by introducing Terri, and then we will also launch a poll if you've ever had experience with probate. So Terri, why don't you begin?
Okay, thank you. I'm glad you could all join me. I'm excited to share what knowledge I have regarding probate and the law. I've worked in the probate court area for over 30 years, so lots of experience, especially with the local courts. And so I'm real excited today to be able to share what I know with you. There is a chat provision, which I think there was a little note when you came on that you can put questions in there, and we'll have time for questions and answers after we're done here. And I know Chris was going to launch a quick survey as to whether you've had any experience with probate or not.
And I think you may have to do that, Terri, at the, oh, just 1 second, please. I think
okay.
I'll be able to launch that for you.
Oh, sorry. I thought, Chris, you were launching it. Sorry, everyone, for the miscommunication, but we'll get there.
Yeah, we're all set.
Okay. And I am seeing it on my screen now about, have you had experience with probate? Either yes or no. It just gives me a little bit of background for each of you as to whether you've had any experience, and then maybe we can share some stories at the end of this on good and bad. I've heard all kinds of things both ways from clients that it wasn't a big deal, it went nice and smooth, and I've heard other people go, wow, you never want to do that. And so that's kind of generally what I hear from a lot of people, is you don't want to go through that. So it looks like we're getting some results here, and I'm seeing about 29% of the people have had some experience with probate, and 71% have not. So that's good for me to know. Gives me kind of a little bit of background. I'm going to try and keep things plain English for you. But, you know, being an attorney, sometimes I may lapse into some of that terminology. I will try not to do that. If you need anything clarified, of course, you can do that in the chat version. So if everyone's ready to go, I'd like to start out. You can see, hopefully everyone can see the PowerPoint that I've cut up, the 4 burdens of probate and how to avoid them. And it's just kind of summarizing, you know, what those burdens are. So in this virtual workshop, you're going to learn the 4 reasons to avoid probate. We're going to talk about myths regarding probate. What is probate? Because that's often a big question. And lastly, can you do it yourself? And more importantly, should you? And so we'll address these things today. And we'll go on to our next screen. And these are kind of the 4 major reasons to avoid probate. And before I get into this, when I'm talking probate today, I'm going to be mainly talking about what happens when someone dies. Probate court does handle a lot of different things, including guardianships and conservatorships, which we do here at the firm. But today we're going to concentrate on why you want to avoid probate when someone dies. So if you look at our slide here, number 1 is loss of privacy. Anyone that has passed away and we're going to have to go through probate for their estate, we are going to have to admit their will to probate. And so when we do that, we're filing it with the probate court. It's going to be public knowledge. anybody who wants to go down to the court and say, so-and-so died, I want to see what their will says, going to be able to see it. You've probably seen things in the news about some of our famous entertainers, and they either did or didn't have a will, or their will is in probate. And so one of the ways to do that is to do proper estate planning ahead of time, so you don't lose that privacy. And we often do that by use of trust. Number two is the cost, and probate can be more expensive than doing trust administration. So someone has a trust, they have their things titled in the trust. We'll go through that a little bit more, but it's less expensive. So when we're talking costs, there are a variety of things here. There's a filing fee with the court. That's like $187. Filing fee is $175 plus some money for the certified letters. So that's one of the least expensive things, is the filing fee. There is an inventory fee that has to be paid to the court, and that fee is based upon how much is going through probate. Is there a house? How much is it worth? And you add all those things up, and then the court has a little calculator. I often just go to Kent County's probate court's website to figure that out. But the most expensive thing, I think, when we're talking about cost, are the attorney fees. And people will say, oh, they're going to take a certain percentage, or they're going to take half. Our process here when we do probate for people is we usually do a flat fee, so you know right up front what your cost is going to be. But the reason you want to avoid probate is most attorneys are charging an hourly fee, and you go talk to an attorney that's charging an hourly fee, and they'll say, I need $2,500 retainer to start this, and they start billing you. And often they're billing in the Kent County area, they're billing at $350 to $450 an hour. They get partway through the probate process and they say, oh, I've used all that $2,500. I need more money. And I've had many clients say to me that they've experienced things in the past where the attorney has charged them for every single phone call, and that is correct. They do. And so the cost for probate can run up very quickly, especially if the beneficiaries start to fight. There's no way to totally protect that. We like to do estate planning so we can put some tools in your estate plan to try and prevent that. I often tell the story about clients that we were meeting with, and they were kind of at each other. They were the kids. And people go back to like when they were 2 years old, I swear sometimes. But they were talking about, as they left the room, the one sister said to the other one, you never gave me orange juice when we were little. And in my mind, I'm thinking, what the heck does orange juice have to do with anything? And then they were getting back to, yes, I did. And no, I didn't because of this. And all of a sudden we were out in the hallway and I just said, stop. Like a mother, my mothering instincts came out. Stop. This doesn't have anything to do with what we need to do today. So it's very important to get your estate plan in place, because otherwise you're going to end up with loss of privacy, the cost. And then number 3 is estate recovery. And this is something that a lot of people don't know about. And this relates to people who have had to apply for Medicaid that are like in a nursing home. When a person retires, they get Medicare. And I always say it's got that word care in it. So that's care for people who have retired. Medicaid has the word aid in it. So I always say that's aid for people who need help paying for things. And with the nursing home costs today being roughly $10,000 a month, there are very few people who can pay for that out of pocket. And Medicare does not pay for the room and board. And so, you're pretty much on your own, or you have to apply for Medicaid. So if you are in long-term care, like a nursing home, on Medicaid, when that person dies, the state of Michigan can come in and get reimbursed for what they have paid for that person's long-term care. And so you're thinking, okay, the house is going to go to the kids. Well, a lot of times the house gets eaten up by the Medicaid expenses when the state of Michigan comes in on a state recovery. And they're pretty hard-nosed on that. I've worked with the assistant attorney generals, and they're like, we can't negotiate this. We can't come down on it. And so there are certain things that come out first, like the administrative costs, like the filing fees, the attorney fees. If the beneficiaries are a spouse or children, there are a few exemptions that get paid first, but otherwise then in the funeral bill. The state of Michigan comes in next. And depending on how long your loved one was in the nursing home, they can take the rest of the estate. Number 4 is creditor claims. And this is something that I hear from our clients when we're talking to them and we have to do probate is you want to wait to pay the creditor claims, but creditors can file a bill in the probate estate to get reimbursed. There are a certain hierarchy of who gets paid first. There's a notice that goes in the newspaper that gives them 4 months to get their bills in. But they, again, are going to get paid before the remainder of the estate goes out to the beneficiaries. And so by subjecting your estate to probate, those are all things that are going to be an expense to the estate and potentially prevent your estate from going where you want it to go. And most people, it's like, I want it to go to my spouse, or I want it to go to my children, or maybe even a charity. But most people want to have control over their estate. So I'll go on to the next screen. And this is one that is just kind of a conglomerate of what I hear a lot from people. And it says probate myths versus truths. I don't have the truths up here. We'll talk about those. But the first one is one I hear pretty consistently. It says, I have a will or a trust, so my estate won't have to go through probate, right? Wrong. A trust can avoid probate if everything gets put into the trust. So there's nothing in the deceased person's name alone that is not titled in the trust or doesn't have a beneficiary on it, with the exception of vehicles. So we do use trust a lot to avoid probate, but I have other people that have a basic will with no living trust. And they come in here and it's like, well, we have this will. Well, why did we do the will if we're going to have to go through probate? The will is an instruction manual basically to the court as to what you want to have happen. But you go back to those 4 reasons to avoid it. You want to avoid going through probate court. So just having a will not avoid probate. If there's something like a house in that person's name or a bank account that doesn't have a beneficiary on it, and it's not in a trust, it's going to go through probate. So that's one that I think is one of the major misconceptions that people have. The next one I have on here is if someone dies without a will, the state will take everything. Sometimes. So that's, I guess, a myth, but not always. If someone dies without a will, the state of Michigan has something called intestate laws. It's a law that we have, and intestate means that person died without a will. And so in the state statute, our legislators have set forth an outline of who's supposed to inherit if a person dies without a will. And some people think, well, my spouse is going to get everything. Not necessarily. Because if there are children of the person that died are not also children of the spouse, so this living spouse has stepchildren, the spouse only gets a certain amount of the estate. And there's a chart as to how much they get. It changes every year. So we have to look that up every year. So if someone though dies without a will, and there's no beneficiary of that person, and occasionally that happens. I mean, we've been, had people doing genealogy type searches to try and find distant relatives. We have one right now that we're working with a lady, and she's an ex-spouse, but she said, oh, I still cared for him, but, I wasn't his spouse, but I said I would take care of his estate. And so she found an old address book. People a lot of times today don't have address books anymore. They have, things on the computer, which then a lot of times you can't get to because you don't know their password. But she found an old address book, and she is going through that, trying to find any distant relatives because his parents are deceased. He didn't have any living siblings. He didn't have any children, so we're out to distant cousins. And so if no relatives can be found, then at that point, the estate may do what they call escheat to the state of Michigan. That's ESCHEATE. I know it's a weird word, but it goes to the state of Michigan. But that's usually a last resort. The third thing on this page is I don't have to leave anything to my spouse, because sometimes people have disagreements with their spouse, or they may have separated but not legally divorced. And so they will say in their will, I'm not leaving anything to my spouse. Well, in probate court, the spouse has rights. They have something called a right to elect against the will. So they can take a portion of that estate, even though it says that you're disinheriting your spouse. However, there are ways to disinherit your spouse. And if that's something that you want to handle, then I would recommend you come in for estate planning. And there are valid reasons people want to disinherit their spouses. I've heard this a lot of times. I'll have an elderly couple I'm talking to, and they may be in their 80s and they've been married 2 years. And they had been married for many years with their spouse, the previous spouse who's deceased. And they saved all this money with their previous spouse with the thought, okay, that's going to go to our children when we're both gone. However, this elderly person meets someone and they get married. They still want that money that they saved with their deceased spouse to go to their children. And oftentimes their other spouse does too, the new couple. And so there's a lot that can be done with proper estate planning. But if not, and they have everything joint, sometimes I hear that, oh, I'm going to make everything joint. It's going to all end up with the survivor of those two. And in my example of the couple that just married, a couple of years before probably one of them is passing away, or they're in their 80s or older, it'll end up with one of the two of them. And then the first one to die, their children may not inherit anything. So it's really important to do your estate planning. So I'm telling you some of the kind of horror stories, but there's a way around all of this. Just don't ignore it. So going on to probate myths versus truths. And the one thing that a lot of people think is the oldest child is the personal representative. And that personal representative is the term we use in Michigan for the executor or the administrator. It's often abbreviated as who's the PR for personal representative, but that's the term we use in Michigan. Oldest child isn't necessarily the personal representative. If you have a will, you can designate, a list of people in your will of who you would like to handle that. The oldest child may be the best person to do it, or they may not be at all. They may have been the one that fought with everyone. And so having a will, and again, we recommend a trust, but having a will naming your personal representative is recommended, because then you get to choose who you think is going to be the best person to administer your will. The other thing is, if you don't have a will, the oldest child is still not the personal representative. There's a hierarchy in the state law as to who that would be. And usually it's the surviving spouse first. And if there's no living spouse, then it's all of the children have an equal right to be the personal representative. And, you don't even have to have a relative if you do a will. If you don't think the kids would be a good choice, you don't have to have that. But otherwise, if you don't, let's say you had 3 children, all 3 children are in equal standing to be a personal representative. And that in itself can cause a fight. So, the best advice I can have is do proper planning. The next item is, if there isn't enough money in the estate, I won't get anything, and I'm going to have to pay the bills out of my own pocket. And that's not true. If you're going to act as a personal representative or as a trustee in a trust, You're not personally liable unless you violate what we call fiduciary duties. If you like abscond with the money or don't use it properly, then you may be personally liable, but not for the bills. And that's one of the things that people are sometimes surprised about when they come to meet us. We'll say, you know, okay, you know, mom or dad died, or, you know, you need to keep the house insured because we want to make sure it doesn't burn down and have a problem. You're going to need to keep the power on. So you're going to have to pay the electric or the gas bill because we don't want frozen pipes, that sort of thing. But what I tell them is not to pay the credit card bills and don't pay the doctor or ambulance bills, which people kind of look at me like, what? And I even had someone here at work who was an accounting position come in, and he's like, well, who pays them then? I'm like, no one. But again, there's a priority of who gets paid first. But if there's not enough money to pay all of the creditors, they may only get 10 cents on the dollar. But it's really important, you know, to handle things properly. Because you can get into trouble. You know, it just needs to be done the correct way. But you won't have to, you know, pull money out of your own pocket. I don't want to be the personal representative because I'm going to have to, you know, spend $5,000 to pay off all of mom's credit card bills. No. The next myth that we want to talk about, and you can see the lovely picture on the screen here of that lovely car that's probably, you can see kind of the grass growing up around the tires and everything. But the deceased person left only a car and a bank account with a couple $1,000s. And we often see this with people who have been in a nursing home, or, you know, people are on a strict budget when they are elderly and they don't have a lot when they pass away. So if they only had a car and a bank account, and you're saying, well, if I have to file for probate, it's going to cost more than those things are worth. We have some shortcuts that we use. So that's a myth that you're going to have to file for probate. There are some shortcut probate methods that we sometimes use. There are some things that we don't involve the court at all. If the only thing that's left is a car and a bank account that's worth, you can use an affidavit procedure on that. If it's less than 24,000, if they died this year, we can get that without even having to go to the court. The car, the Secretary of State, if they're a relative like a spouse or children, that can be done straight through the Secretary of State without having to involve the probate court. So that's another myth, and it's an important reason why you should contact a competent attorney who knows these shortcuts, because otherwise you go to somebody and they're like, oh, you got $2,000 and you got a car. Okay, well, it's going to cost X number of dollars and we're going to do a full probate, and there may not be any need for it at all. Okay, and the next slide here is, can you file for probate yourself, and should you? And I think you know what my answer is going to be based upon everything else that that I've been stating, but there's nothing to prevent you from legally filing the probate court forms if you need to do that with the court. But you are going to be required to follow the state laws and the court rules. And telling the judge that, well, I didn't know, I'm not an attorney. Nope, that doesn't cut it. Also, the court will not give you legal advice, because some people are like, it's a really easy form. You just go up to the counter and they'll help you. Well, first of all, in Kent County, I don't think the probate court counter is open yet because of COVID. But even if it is, if you ask for a petition, they may give you the form, but they're not going to give you advice on how to fill it out. The Kent County probate court has a website under Access Kent, and they have many of the forms that are needed there. And these forms, if you look at them, they're really deceiving because they look really easy. It looks like, okay, I just put their name in here, I put their name here, their date of death and the time of death, that sort of thing. But it doesn't necessarily tell you every form you're going to need. It also doesn't give you some of the guidance that an attorney would as to some of the exemptions you may be entitled to, whether you pay a a creditor bill or not. There's a lot of specifics about it. This next slide is a picture of Judge David M. Murkowski. He is our Chief Judge of the Probate Court in Kent County. And I've presented cases in front of him for a number of years. I've been with Carrier a little over 5 years. And before that, I worked for another firm where I appeared in front of him since the time he took the bench. And looking on the court's website that I was just referring to, here's a quote from Judge Murkowski, and I can actually see him saying it from the bench because I've been in court before we had COVID. Used to have to sit in court and wait for your case to be called. I actually learned a lot doing that because you could see, the different cases that went on. But his quote says, "An attorney should be consulted and retained to handle the probate proceedings. Estates are almost always complicated enough to justify such professional services. My experience as a judge has been that in most cases in which someone tried to probate an estate without legal assistance, it has been a disaster in the decision." And I really can see him saying that. I have also met with people sometimes that are like, we started this, but this is a problem and that's a problem. And by waiting to get an attorney until midway through, some of those problems either cannot be reversed or it's going to be a lot more expensive and time consuming to reverse those. And so it's always better to seek the counsel of a competent attorney. So this is often a question. My loved one just passed away. What do I do next? And it's not unusual for us to get a phone call the day after someone passed. What do I do? They died. And so this is just a quick checklist. One is check for a prepaid funeral contract. A lot of people, especially if someone is going into a nursing home and applying for Medicaid, they often pay for a prepaid funeral contract. And so if they've done that, then of course you're going to want to contact that funeral home. Some people are like, how do I know if they've done that? I've seen a number of people put their prepaid funeral contract right in, like if they have like a 3-ring binder like we do for our estate plans, they'll put it in that front pocket, or they may clip it in the back. If it's so often that a person has passed away that they don't tell anybody anything that's going on. The other thing is if you think maybe in the last few years they might have done something, look through their checkbook register if you have access to that. Number 2, notify friends and family that your loved one has passed. Number 3, look for a will, a trust, and asset documentation. I think will's pretty clear what we're looking for. Trust. If you have done a trust with our firm, we, as long as the person's competent, we've always done a will with it, and it would be in your 3-ring binder. But you don't have to pull it out or do anything with it immediately, but you do need to find it. Same thing with the trust. Now, asset documentation, what is that? Well, you think about assets. What are assets? So documentation. If there's a car, you're going to want to find the car title. If there's real estate, the deed, and that's one that oftentimes people have difficulty finding because it may have been very old. There are ways around that. We can help you with that. If we're retained to help you, there's ways on the internet to various counties to get the deeds. Bank account statements, that sort of thing, stocks, life insurance, all that sort of thing. You want to be gathering all of that. You don't have to do that the day they died. It's not going away. It's just a matter that those are some of the things you can start doing. You want to make the funeral arrangements, and then also call the law offices of David Carrier. We don't usually meet with someone unless there really is an emergency, like the day after someone died, because it takes a little while to gather all this information. If there is anything that's got to go through probate court, we have to have the death certificate before we can file that with probate court. So just keep those things in mind. But if you call here, we like to know that your loved one has passed, especially if you're a current client of ours. You can make an appointment to meet with one of our attorneys. There may not be anything to be done or very little, but consultations, initial consultations here are always free of charge. Okay, what is probate? I keep talking probate, and I think a lot of people think they know what it is. And as I started out our discussion, one of the things I said is I was going to talk about it from the aspect of if your loved one had died. Probate handles a lot of other things as well. Like I said, guardianships, conservatorships, needing to get minors, settlements approved, that sort of thing. But probate, in the way we're talking about it today, is a way of transferring assets to a beneficiary after the asset holder has passed away. So it's a way of getting property, bank accounts, other things transferred to the beneficiary. It's necessary to take it through probate if there's no joint owner or beneficiary. If a bank account is joint with a joint owner, it goes to that joint owner. Sometimes we'll see bank accounts that have what we call POD, that stands for pay on death. So your bank account of your loved one may have a beneficiary on it. So those things don't go through probate. People have sometimes done what are commonly referred to as ladybird deeds. And if the people on that deed have all died that were deeding it, usually at the end it will say when we're gone, it goes to John, Bob, and Susie as an example. There are some problems with doing it that way, but it will not go through probate if those people are still living. So the will that we've been talking about serves as an instruction manual to the probate court as who you want to handle things and how you want them distributed. So that's what probate is. And just for a comment, if you're really curious as to what things go on in court, Kent County Probate Court, when they're in session, you can watch the court sessions on YouTube. And what I did was I just Googled YouTube Kent County Probate Court. And then if they're live, you click on the little link you get, and it'll come up and it'll say if they're live, and you can see everyone that's appearing on a Zoom hearing. And Kent County is primarily using the Zoom hearings right now. So the next screen is what happens when probate's required. And this is just kind of a standard, steps. There's some other little things that happen in here, but just to give you a general view. If you're working with us, we walk you right through the whole process. I mean, you're going to need to sign some things, but people come in and they're all afraid. I'm like, don't be afraid. We'll walk you right through it. We'll be here, step and step guiding you through this process. So one of the first things that needs to be done is the death certificate, or a copy of the death certificate, and the original will, if there is one, are required to be filed with the court. There's no time limit on that. The law says within a reasonable time, but I don't think anyone's defined a reasonable time. We do that as a courtesy for our clients, whether there's anything to probate or not. But it does have to be the original will. And when we sign things here, we usually sign in blue ink. So it could still be copied and show up as blue ink, but if you've got the original binder of trust documents, usually you have the original will. We do not keep original wills. The next thing is a petition or application is completed and filed with a filing fee, along with a number of other required documents. And that's what I was referring to earlier when I was talking about those fill in the blank forms. One of the forms that has to be filed is a testimony of interested parties. And so any heir, whether, let's say they had a will and it says, I'm leaving it all to Mary and I'm disinheriting John. Well, John still has to be on this testimony of interested parties because he is related to the deceased person. So you can't just avoid notifying them. The next document is a little bit of an expansion on that, a supplemental testimony of interested parties. And this gets people who are beneficiaries get listed here who are not heirs, who are not related biologically to the person. Could be a charity, could be a trust, could be your next door neighbor. Then other documents that would be filed with the court would be an acceptance of an appointment. That basically says that the person who was appointed personal representative is the one that usually files the petition, that they're agreeing to be the personal representative. You can't force someone to be personal representative. And then letters of authority, sounds like a couple documents. It's a two-sided, one-page document from the court, and it basically says that the person was appointed as personal representative. It's the document you can take to the bank or you would take to a real estate closing that says you have authority to handle the estate. One of the other things that would come from the court would be a registrar's order or an order of the court admitting the will to probate. Okay, responsibilities. Once you're appointed personal representative, and we meet with people who are like, I don't want to have to do all this. Why did they choose me? But as I said, we make it easy for you. We guide you along the whole process. But this is why I think you need an attorney, because there is more to do than just fill out a couple fill in the blank forms. One of the things that's done is there's a notice put in the newspaper to creditors of the deceased person. It just goes in one time, but it tells them that they have 4 months to file their bills and their claims against the estate. If they don't do it in that 4-month time period, they're barred. So after 4 months, you know you're not getting any more bills that you have to worry about in the estate. There's also something called a notice to known creditors. So if you were getting bills for the credit cards and that sort of thing, and we were handling that probate, we would send each one of those people you'd gotten a bill on a notice to known creditors. Filing for exemptions. This can be really important if there's not much in the estate and there's creditor claims. The spouse has certain exemptions. We see it a lot of times for children. Mom and dad are gone, you know, there's nothing really left and all the creditors are going to eat everything up. Well, there's something called exempt tangible personal property. And this varies from year to year as it's indexed for inflation. But it would let the children share, I think it's 15 or 16,000 this year. So you would at least get that much that the children would share, not each child, but they get to share that. And so that's some of the reasons why you want to contact an attorney, because there are some provisions out there that really aren't clear if you're just filling out forms. Obtain a tax EIN and open a bank account. A tax EIN, it stands for employer identification number, and that's like a social security number for the estate. Once you get that, then you can open up a bank account, you know, for the decedent's estate. You're going to gather and protect all of the assets. Like I talked about before, looking for bank account statements, making sure there's insurance on the house. Handle liquidation of assets. Do stocks have to be cashed in? Does the house have to be sold? How do we do that? And so again, that's another responsibility. You're going to file an inventory with the court that says everything you started out with. That doesn't mean every teacup, spoon, fork. It's the major things, the bank accounts, the real estate. Sometimes we'll just put miscellaneous household property on there. If you have anything expensive like a Picasso hanging on the wall, of course, we would want to list that as well. And then once that's filed with the court, that's what they base that inventory fee on. And if you don't pay it timely, they'll send you a little notice that you need to pay it. You also will need to pay the expenses of the estate and the legally enforceable creditor claims after that 4-month time period has come up. But that's, again, some are not legally enforceable. And so we would be giving you advice on that. Prepare an accounting. So you start out with your inventory, which is the dollar amounts of everything that you have. In accounting, you're going to need to advise the other beneficiaries, all the money that came in, interest, dividends, maybe an income tax refund, the money that went out, the expenses, maybe you're paying to have the lawn mowed, paying the mortgage, the utilities. And so you'd start with your inventory, add in the amounts that came in and subtract the expenses. And hopefully what you have left over balances with what the bank account says. And then there are some documents that need to be prepared to close out the estate. And then we do a sworn statement to close. And then after 28 days, that's filed with the court, we get something called a certificate of completion. So you do get something that says, okay, you're all done. So probate's a lot of work and it's very technical. And so a couple statements here. You can avoid your loved ones having to deal with probate court by making sure you have your own estate plan in place. Call the law offices of David L. Carrier PC to learn how to protect your assets. It also helps prevent your loved ones from fighting. We can't totally avoid that always, but having a good plan in place is the way to do that. And if you're faced with needing to file probate for a loved one who's passed away, don't panic or try to do it yourself. Avoid that disaster that Judge Murkowski talked about in his quote there. Call our office. We have a very experienced team of professionals who know all the ins and outs of probate. And lastly, I think I'm on to our question and answer session. And Chris, are there some questions and answers or anything in the chat? I don't see anything.
I have a question. There was a question about the length of time you can, I don't know if there's such thing as a typical probate case, but what does that time frame look like?
Okay, we internally here, we always set a goal of 6 months. The court rules say it has to be open at least 5 months. And the reason we say 6 months is usually that first month we're gathering information, getting the paperwork together. The 4-month time period is built into it for the creditor claim. So we'll publish that notice in the legal newspaper and we have to wait the 4 months until that is up. And so our goal is, okay, creditor time period is up. Can we now do all the final paperwork and indicate who is getting what? So we use 6 months as our goal. Doesn't always happen because we may run into some problems. Depends sometimes if there's real estate to be sold, what the market's like, is there a family member trying to buy something? Are we having some issues with one of the life insurance companies or we had one with, I don't know if it was IRAs or annuities, 3 of them with the same company, and we sent all the claim forms in for our client at the same time. 2 of them, we got them right back. One of them, they've told us 3 times they lost the forms. And that can be so frustrating. But we have some wonderful paralegals that work in our department that I don't know where they get their patience from. I'd be ready to throw the phone out the window, but they're staying on the phone. Every Monday they're calling, they have it on their calendar. But, our goal is 6 months. People hear, it's going to take 2 years. No, 6 months is what we try to do. Like I say, it doesn't always happen because, we may run into some stumbling blocks, but we've got it all set up so that kind of a real process and a real system as to this has to be done first, then we do this. And my coworker says we have kind of 3 steps. One is getting you your driver's license, the stuff that you need to have to be able to handle things and administer things. We have the middle step, which is where we're liquidating assets and getting everything so it'll be ready to distribute. And then the final step where we're calculating all the figures and getting it all set up to be distributed according to what the will says, or if they didn't have a will, the intestate laws, or if they had a trust.
Another question we got was if there is property involved, and who's paying the bills in the interim? And are there certain bills, like what if no one can pay the bills until after probate, if no one can take responsibility to pay the bills?
Okay.
How does that work?
So I'm assuming we're talking about like a home, probably.
Yes,
When we're talking about property.
yes, yep.
And sometimes people do have the ability to pay out of their own pocket. They may have their own money, but a lot of people don't.
Right.
If they do have the ability to pay out of their own pocket, they can kind of like advance the money and then they'll get reimbursed. The other thing to do is to, if there's like a mortgage, contact the mortgage company, say, hey, listen, we're probating. It's going to take a little while. We're going to have to sell the property. So that will usually put the mortgage company kind of on hold. Utilities, that's a little harder question. But you're going to want to cancel utilities for like cable and those sorts of things, but you need to keep the basic things on, your water and sewer, electric, gas. And a lot of these companies will work with you if you talk to them about it. But if there's other assets in the estate, let's say, it's mom or dad's house, they had a checking account. As soon as we get those letters of authority, which what it usually happens is the initial packet goes into the probate court, and then they pretty much rubber stamp it and send it right back. So usually we get those letters of authority within a week to 2 weeks of filing everything with the court. And as soon as you get those letters of authority, you'll have access to the bank account. And so if there's money there, you can use that money to pay for house expenses.
So you don't really have to wait till let's just say the house is sold, or that 6-month period. You actually would potentially have access to some of the assets prior to that 6 months.
Correct.
Or whenever. Okay.
Correct. And also you don't have to wait until that creditor claim period ends, that 4 months I was talking about, to list the house. Or sell the house. As soon as you have your letters of authority from the court, you're ready to go. You've been appointed and you have authority to handle everything. You just can't distribute it out and pay all the claims until after the 4 months.
Okay. Well, I thought that was interesting what you said about the credit cards and some of the things that shouldn't be paid, that are not the debt of would it be beneficiaries or whatever?
Correct. And some of those may be entitled to be paid. But a lot of times, we may say there's not enough money to pay all the creditors, or it may be eaten up by like that exempt tangible personal property, and we'll send them letters and respond to any of the creditor claims. But that's the nice thing with a trust is, we aren't in that court situation. And so a lot of times we can avoid some of those. But, normally if you tell like a credit card company or a doctor, so-and-so died, we don't think there's going to be anything going through probate, or there's not going to be sufficient assets in probate, they just close their account out. And people are real surprised about that. It's like a cost of doing business. They're like, okay, they're dead. All right, you won't hear from us. We have a few, though, that even when there hasn't been anything to pay them with, they keep hounding our clients. And we, that's one of the things that we do when we're representing, is we keep sending letters, they're represented, do not contact them, those sorts of things.
Well, just looking, I think that was our last question. What I'd like to do is launch a final poll on the presentation today.
Okay.
And I'll do that now.
Okay.
And I also want everyone to know that if you have any further questions for Terri, her information is here. If you would like to make an appointment with Terri, you can just call the number here, call our office. She'll be happy to meet with you. And as you know, all our meetings, there's no cost for that. Great opportunity to get some information. And feel free to share this information with your family and friends. I'd also like you to know that our next educational series will be with attorney Lee Dillard. Again, you can register on our website, and she will be talking about the responsibilities of being a trustee. Again, I think that's going to be another really good one. If this webinar as well was recorded, and it will be on the website probably by the beginning of next week. And so I appreciate everyone coming today. And for those who are filling out the poll, that's awesome. I'm gonna end the poll And we look forward to seeing you at our next educational series. And I thank you so much.
I appreciate everyone today listening. And again, if you have any questions or you have something that was a little more confidential that you want to talk to me directly about, I'd love to talk to you.
Have a great day, everyone.
Bye-bye.